Okay, Madam Chair, live stream is connected. You may begin.
Okay, I hereby call to order the meeting of the Independent Ethics Review Board on Thursday, June 10th at 2021 at 3 p.m. Item 1 is public comment. Mr. Secretary, do we have any public comments?
No, ma'am. No one submitted public comments.
Item 2 is consideration of an action on the minutes of February 11th, 2021 meeting. Are there any corrections to the minutes? Okay. If there are no corrections to the minutes, do I have a motion to approve?
A motion to approve.
Second.
All in favor?
Aye.
Aye.
Any opposed? Okay, minutes have been approved. Okay. Item 3 is review of and discussion on recent ethics articles of interest. So has everybody had a chance to review the articles that were sent over? It looks like Dallas has been quite busy as of late. So the first article is specifically about the mayor. What did you think as far as the complaint that was filed? Not everyone speak at once.
I thought he was speaking more personally, wasn't necessarily using his position to endorse the candidates.
Anyone else? Did you think that this would violate our code of ethics?
Well, is social media, I mean, are there rules set up for social media at this point? There should be, but I'm just wondering if, you know, that if he thought that social media was more private.
So, I mean, based on what I've seen in our code of ethics, sorry, Andrew, were you about to say something?
No, I don't think there's a difference between where you say it and how you say it. If it's said in any way publicly, it's still said.
So did you feel, go ahead, sorry.
No, I said I agree. But what I'm saying is this mayor clearly thought that social media was his opinion, you know, and when you're in that position, if you're the mayor of a city, it's not like he was, you know, mayor of nowhere, right? He's the mayor of a large city. What you say can and will be held against you.
But it was the same as where you can speak on.
Sorry, I guess there's some background noise. So Rachel, did you feel that it violated our code of ethics?
I think it did. Because I feel like our code of ethics holds elected officials to a certain standard.
I just, after looking at our code of ethics, I wasn't super clear as to what section that would actually fall under as far as his actual tweeting or retweeting those actions. Because I mean, it's not necessarily, he's not receiving monetary gain from it. And there's no monetary conflict of interest per se. It wasn't regarding a vote. So did anyone else find like a section where it might have been in violation?
I think our code also addresses any personal gain. It doesn't have to be monetary. And if you can endorse somebody and get them to support you or rubber stamp your stuff, it would fall under that.
I agree, because once you're the mayor, you're using that mayor platform. You're the mayor wherever you go. People are going to recognize you and say, oh, this is what the mayor said. It's not like he would take off that hat, unless he goes back into his own home.
Yeah, but I think in this instance, he's trying to leverage his title, if you will, to get someone else elected. Now, it could be that after that person got elected, if there was some favor that was given back, that to me would be more of the violation. I mean, right now it's more of a question of should people be allowed to use, their titles, which I think we see in the world today that's done quite readily in the political scene. So I guess I just didn't see it. I mean, I whether I feel it's wrong, I don't think it's really right, but I don't know if it's like it. To me, it's not as a part of what we've got in the Code of Ethics.
I have a question. You remember when we first joined the Ethics Council, we all had to take we had that training that says whatever you say out there can cause you problems. So be careful what you say, be careful what you, I'm guessing the mayor had that talk. It's not like he plopped into that position without some kind of training. So I think he would have known. Go ahead, sorry.
Are you referencing the section on appearances?
I'm not sure which section it is, but I remember our training where, don't post anything, don't go out there and talk unless, because people will, you are recognized as part of being on the, this particular council. Anyone else?
I can read you the section if you'd like. Section 2-82 appearances. An official must not appear before any board or commission except on their own behalf. If they write a letter to the editor or any publicly distributed writing, they are required to clearly disclose at the beginning of the speech or writing whether they are appearing in their personal capacity or their official capacity. There is no prohibition, it just requires them to state which hat they are wearing.
Well, when he did the letter, he addressed it as pastor so-and-so and not as mayor. So I think he was establishing that as a personal view.
I definitely think it's a gray area. I mean, we've read some of these articles and seen different scenarios where it seems pretty cut and dry, and maybe, some of the other articles that we review subsequently might be a little bit more clear. But to me, I mean, it seems a little bit of a gray area.
Oh, wait, the candidate that he was supporting is a pastor, not Johnson himself.
I think a lot of our code is written based on the smell test. And I'm not sure that this would pass.
I definitely think it would not be dismissed immediately. I think it would be something that we would have to discuss and look at in more detail. To me, it's not cut and dry based on how our code reads, whether or not this was a direct violation. But I definitely think it would warrant a discussion. Any other?
Yeah, I agree. It definitely would be something to look at and to discuss out. It like you say, it's a gray area. It wasn't necessarily right, but was there enough there for a board to find wrongdoing, or did he skate the rim enough?
Because if he was former mayor or past mayor, something else, that's a different story. But he's in that seat at this time. It's not like he doesn't know that what he says holds value. He knows that.
And I just think that as social media continues to grow and grow, and this is the way people communicate, I mean, this just falls into definitions, and retweeting, it's an action, so, and there's other ways of social media of communicating like that.
And it might just be that we look at it and go, don't think it's right, and there's an admonition, no fine, no penalty, no sanctions, just, hey, please don't do it again.
That's fair.
Any other comments? Sorry, go ahead.
I think if we just convened over a complaint about this, it would send the message of maybe you shouldn't have done it.
I agree with that. I think, rather than dismissing it immediately, having the discussion and then seeing what that outcome is, I think is fair. I mean, Meredith, would this make this out of your office into our hands?
Yes, it would. This would not be something I would make a determination on. The mayor is subject to the code of ethics, and this is something that may be a violation. It's not for me to determine whether something is or is not a violation, but if it's close enough to being something that would be regulated by this board, it's for you to decide, not for me. Part of the reason I bring you these articles is to have this discussion for you to apply our code to them, recognizing that our code may be different than other cities. They may have an explicit prohibition that we don't have. But this is also an opportunity if you want to make suggestions on any revisions you think our code might need to address any behaviors that was not considered when the task force had their last review.
I mean, I think, go ahead.
So Meredith, sorry, go ahead.
I would say if we do decide to add something to the policy, I wouldn't want to make it specific in terms of the technology used, because a new technology comes along and it's not stated in the policy, then they go, well, you didn't specifically say that. So if we convey the concept and let the technology change as it does, we don't have to worry about updating to say print, television, radio. Oh, well, this is social media. It's none of them.
I will add that if someone had come to me and asked for an ethics opinion, I would have advised against doing that under Chapter 171 and would have pointed out that it would not be a good idea, and I've actually done that in the past. There has been requests from various boards and commissions, can I endorse this candidate? It may not have been a city candidate they wanted to endorse, but I reminded them every single time that it must be in your personal capacity and that it does not reflect well in your professional capacity, because depending on who wins, it may make it more difficult for you to conduct your business.
Or negatively impact the city if the person who is elected has any input or say is higher, in the county or something like that, or the state, that they can exact revenge.
So Mayor, just for my clarity on the verbiage that you read from the Code of Ethics, so this board would be, it's an interpretation of whether they use their name, because I don't think in this case it was legitimately, he sort of went out as specific as the mayor, but not in his personal opinion, not as part of his personal opinion or anything from that perspective. Is that would be an interpretation for any communication then, like in any one of the council, or like say the mayor would communicate in any capacity, whether it be an endorsement or any kind of communication. Would that be correct?
That would be part of whether or not I would forward it on to this board. If he was clear, if he was very clear that he said that he did it in his personal capacity, his personal capacity is not within your purview. Because he did it with his title, that would put it within your purview, and it would definitely be sent to you for review. We probably want to look at the facts attached to it to determine whether or not in his personal capacity it would have been a violation. It most likely still would have been sent to you, because it's, like I said, it's not my responsibility. That's why you have all been appointed. You are the moral compass for our elected officials, and it's incumbent upon you to make these determinations. I just get to be the person who passes the paper over.
So I think back to what Andrew was saying, we wouldn't really ever have to make any kind of changes for the platform that's used, whether it's a tweet, whether it's Facebook. I mean, it should be all encompassing of any communication. Right. I mean, I don't think that's really the question. It's really how he communicated.
Fred, were you going to add something?
I was just going to agree with Andrew and everyone else is that it doesn't matter the platform that's used
Right.
because those are going to change.
Yep.
I mean, as far as that goes, it just could be an instant message that gets leaked somehow.
Exactly.
Well, and I was going to say, with video being more the platform, even that's the next generation is going to be all mostly video like TikTok, and people are putting things purposely, in the background to send messages. I know. So I agree. Like
Yeah.
social media is just going to, next thing you know, we're going to have little screens in our class, that we're going to get messages everywhere.
Well, you do know they have those already.
No, they do, but it's going to be more mainstream. I should say more mainstream. Yeah. Yeah. I mean, like you and I would be having I don't have those.
Right.
This definitely fell under what we always called navigating the gray. And I think, social media is now being more and more construed as, reflective of whatever entity that's employing you, or if you were a mayor, a council member. So you're seeing in multitude of scenarios where individuals are actually losing their jobs because of things they've said in a personal capacity, even though, he did not say whether it was personal or acting within the office. I think, the inference is that it is reflective of the office, which is why I think it would, warrant a discussion at the very least.
Agree.
Any other comments on this particular article before we look at the next? Okay. So the next article I have is the zoning case, and it's the second and third article because I think this is our first time where we actually get to see a complaint reviewed and the actual decision. So that's, exciting. So did anyone have any initial comments or thoughts regarding the zoning complaint that was brought forth in, again, City of Dallas, who's been very busy the last several months?
Well, I was pretty surprised that it was excused in the second article, because at least in our case, I think it's a clear violation of our code of ethics.
Yeah.
In my opinion.
So I definitely agree as far as like our code of ethics seems to be a little bit more specific in regards to the actual complaint, but the complaint probably would never rise to our board because it was submitted anonymously.
Oh, good
So,
point.
I think that's something that was not a red flag, but, something that jumped off the page to me was the fact that it was an anonymous complaint. And ours we require that complaints are signed and sworn. I don't know if that's the right language, Meredith, but something to that effect.
Meredith?
Oh, mute.
Okay.
I'm sorry, Andrew, I didn't hear your question.
If somebody were to go into your office and say, hey, so-and-so did this, would you encourage them to sign it and let them know that not much is going to happen if they don't?
Absolutely. I've actually had phone calls from members on our boards and commissions and city council who want to tattle on each other. And I use tattle only because they refuse to put it in writing. And I said, I am not the complaint department. I appreciate you've been selected by either by your peers or by the citizens to serve on that board or the commission or council. I am not the judge here. You can complain to me all day long and nothing will happen until you put your name on a piece of paper, write this out, and hand it to the city secretary and say you did it under oath. Nothing's going to happen. And so complaining to me does absolutely no good. If this is a concern you have, you must put it in writing. And the person who you're accusing has a right to know who you are. Mm-hmm. You can't just randomly make stuff up or be mad about something and not have the appointed or elected official have the opportunity to know who they need to address. And so without that, we would not take it.
And I had a similar.
I do encourage it.
I had a similar question, Meredith. So would a complaint like this even make the papers in Sugar Land? Because it's not how did it's not a legitimate complaint, or I guess they could go to the papers, but would it, whoever's writing the article, like do investigation and say this is not a legitimate complaint? Or I thought of that when I saw that it was anonymous.
Okay, I'm going to have to defer to Andrew for that question as far as what the media would and would not cover.
They would make a phone call or two probably, and then they would write the article whether there was any validity, truth, or evidence or not. They do that all the time because they don't really care and they don't have to be right anymore. And so, yes, we would see the article, and then they would expect whoever was accused to come to them and tell them their version of the truth. But yeah, we would see it.
I know it sounds kind of naive, but knowing that we have this code, nothing's going to happen. So
I think that was his point as well.
Right. Yeah, I agree.
So I provided you with this article for a couple of reasons. One, to see if you would notice the distinction between anonymous and non-anonymous, and I'm just so excited you saw that right off the bat, and nobody suggested we change our code, because I do think it is important for us to know who is making the complaint. But I was also curious kind of about how your thought process would be as far as the radius, as if he was within a notification, and whether or not you believe it to be a complaint since he was located outside of the extended radius. The notification radius for a different case.
Well, I think even looking at that with the radius, I mean, you still have to look at intent, and you look at the history of his company, and he's never handled deals like this before. I mean, to me, it gives a lot of evidence that it was a clear intent of him using his position that he even got the opportunity to do that. So it was a monetary gain because of his position is the way I would start looking at it.
So in my mind, because he failed to disclose it and continued forward with the vote, even though he voted potentially against his own personal gain, I feel like there's somewhat of a violation there, because he should have abstained from the vote and at the very least disclosed the conflict.
Yeah.
Go ahead.
Especially because I think it says 80% of his income is related to this.
Yeah.
And that's significant.
And we also wouldn't know their financial status. You can profit by losing money in a deal just as well as you can profit by making money in a deal. And so voting against it might have been in his best favor financially.
But I think our code says that it's a financial interest. If a member has a financial interest, they have to abstain. They don't necessarily talk about if they're going to profit or loss from it. But he clearly had a financial interest in it.
Yes, definitely. Being outside the radius, I mean, to make it not look so fishy, at least report it and abstain from the vote. And I think he would have kind of been transparent in that way, but not disclosing it and still voting, even whether he votes yes or no, I think he made a violation with that.
Would you feel comfortable with him being a real estate broker and representing properties in other districts other than his own?
Yeah. Well, if the financial interest is still there, no.
I think there could be a perceived conflict, whether it's direct or indirect. I think, I always default to disclosure. So a lot can be alleviated with disclosing it. So if it's in another district, whether or not, what the financial implications would be, it's still a conflict, and it's still, at the very least, it's a perceived conflict, which can create similar issues as an actual conflict. So my issue is always with disclosure. So if you're forthcoming about the information, you can disclose it. You know, I'm not sure about the procedures, but I mean, it could even be a discussion as to whether or not you need to abstain, but no one has that benefit of that knowledge and that discussion, at very least a disclosure of the information.
Well, you take it to the city attorney and see if you get a get out of jail free card.
I don't know that you'd want me to tell you how our department would have ruled on this had it come to us. We would have given him the get out of jail free card because it was outside the statutory notification area, but we would have told him that it doesn't smell very good, and this would be a very good time for him to take a bathroom break.
Right. A lot can be avoided by just actually being forthcoming.
No, I agree with Kristen.
Absolutely. We would have told him that he did not legally, under state law, have a conflict, but that it didn't look very good. And like I said, we'd probably suggest that he take a bathroom break or pop over to Starbucks or something for that item.
Any other comments regarding these two articles? I was very excited to see the beginning and the end, because we often see the beginning or we just hear about the output. So it's interesting to see where it started and how it ended up. Okay. The last article was regarding the actual code of ethics for was it the city of Laredo? Is that correct?
Mm-hmm.
What were the initial thoughts around this one?
I would, for one, was very surprised that they charged him the attorney's fees that they did, going into it. Because I think he was doing it in good faith and trying to help the city. So I would hope that our board would not have charged in a similar case the $7,900 or whatever it was in attorney's fees.
Who else?
I just thought it was interesting that the route that he took. I mean, if he was upset, I was, why did he not go to council first? I mean, it seems like that's where this issue sort of surfaced. Because they're the ones that voted. I mean, yeah. I mean,
sorry.
Go ahead.
It raised a question for me, just in like a general question, that would we have insight or visibility into complaints that have not risen to our board? So, go ahead.
Well, I would think we would, right? We wouldn't have that background.
If it doesn't get set forth to if it doesn't pass Meredith's desk onto us, and again, she's just looking to see if it's applicable, and that the code of ethics governs the complaint itself and the individual that the complaint is about. I'm curious if those situations have arisen. No.
We have yet to have a sworn complaint, frivolous or non-frivolous. But if this were to come across, we would contact the individual and tell them that this board, we'd provide in writing, this board does not have jurisdiction, and that they need to talk to a council member or the mayor, and we would put them on for public comment at a council meeting, so that they would have an opportunity to voice their concerns there. But you would not have an opportunity to deem it frivolous. This is not one of the items you have grounds to deem something frivolous. But you most likely would not be provided a report of any mistaken complaints filed that didn't make it to you.
So Sugar Land has a bumper, so to speak, that Laredo clearly did not. He went straight to the Ethics Commission, and I think we have you to come to and say, hey, what do you think? And I think that makes a difference. I think we've put in that little bumper so that it doesn't go through all that. It doesn't pick up $7,500 worth of attorney's fees and then say, oh, nope, it was frivolous.
Just for the minutes, I want to clarify that your statement of what do I think is only whether or not the person or the action is governed by this code. I don't want to the minutes to reflect that I make any decisions whatsoever. I want it to be clear that that's entirely up to you. So.
Thank you. And that was clear to me as well. What other comments, concerns, questions have arisen from this article?
I thought it was punitive. I felt like the 7,500 was really punitive. You know, here, let me smack you on the wrist for coming out with this in the first place. That's what I thought.
Any other final thoughts? Okay. Item 4 on the agenda is the review of and discussion on the ethics hearings procedures that Meredith so kindly drafted for us to review and take into consideration and discuss.
So I will just briefly introduce this item and then hand it back over to the chair. This is the hearing procedures that were previously adopted when City Council was the board to oversee this, with substantial revisions and comments added based on your last ethics meeting. This is just my preliminary throwing things down on a piece of paper. This is your opportunity to slash and burn and make any changes and improvements that you deem are necessary, and there's no hard feelings whatsoever because I know significant improvements can be made. So I will go back to a note-taking role and let the chair back in charge of the meeting.
Don't venture too far. No, I actually thought it was a great jumping off point in general, and I think I know we discussed this last time, but I think as we become more and more mature as a board, even though we have not received an actual complaint, I think it's, well preparing us for, if we do receive a complaint, because as we looked at the previous articles, they didn't have that catch all that we have, where we have a triage process for the complaints that city did not. So as we become more and more mature and robust in our procedures, I think it'll benefit us and, help move everything along forward and prevent a little bit of that uncertainty, since we have not received a complaint thus far, and we hope to never receive a complaint, since that everyone is acting within the code. Do we want to just kind of take it from the page, or I know there was a very specific section with the response from the respondent that requires discussion. I'm going to punt briefly to you, Meredith, just to see if there was any procedure that you envisioned when this was drafted as far as the review.
It would be helpful to me if we could just go in order of the document.
Okay.
I'll be taking notes as your comments. The big gaping hole is because I didn't have any notes from the last meeting as to any directions from this board as to what you would like to go there.
Okay. So item 1, definitions. I don't have any comments or clarifications in this regard. Does anybody have any changes, items within the definitions section? Okay.
So the only thing, I don't know if it would go here, Krista, is that my thought was, and maybe it's outside of this document, because at least in reading through some of the examples we had, it seemed like some of these complaints may take on for a period of time. So how would we handle alternates? So for instance, if you take the board and then something happens, so similar to like a trial, is there a process where you have one of the alternates just going through the process as well so they could step in? Or is that like something that we would have on the outside of these procedures, just so we would know how to handle that in the event that would occur? And I didn't know if that would need to be in a definition of an alternate.
I think that's a very good question. Part of that will be covered in the city's boards and commissions policy.
Okay.
So we are required to have a quorum for this board to hear any cases. My preference would always be that the alternates always attend every meeting, that we have all 9 individuals sitting on the board so that anybody is ready at any point in time. If a case comes forward, I would request that the 7 members sit up on the panel, on the dais, and the 2 alternates sit in the audience so that they are actually listed as attending the meeting in the alternate capacity. But if your meeting or your hearing goes over, that way you have already been exposed to all the information in the case. You have all the documents necessary. You've heard the discussion. And should the hearing be carried over to another meeting and we have an absence, that you will be prepared to step up and that we don't have to hold the hearing over or start over because we don't have a quorum. But just like I do for the ZBA or the BSC, even though it doesn't take everybody to be a quorum, I try to give a full panel vote because I think that is the most just result we can offer. So that my goal is to always have 7 people voting. If you would like that added to this procedures, I'm happy to add that.
I just didn't know where it would need to sit, but if it's already in a procedure for the boards, and I'm fine with that. It just sort of dawned on me reading through that do we need to have that just in the event that occurs? So I think your explanation was very good.
I can easily add language for you to discuss at your next meeting and decide if you want to keep it or take it out.
Okay.
Thanks, Mary. Item 2, the administrative matters and the intake process. Any initial comments, concerns regarding this particular section?
On the intake process, at what point does the person provide evidence? And if they come forward to Meredith and say, this is my complaint, it's signed, here's my evidence, who safeguards that and preserves it until it gets to us?
Per the ordinance, that would be the city secretary. The document is turned into the city secretary, and then it's turned over to me to review to see if it meets the requirements to get before you. But the city secretary's office will always be the document holder. And as far as evidence, that would be brought forward during your hearing. So only
if they turned it into you at the same time they make the complaint, you can say, I'll hold on to it, leave the secretary to her. Do you ask them, hold on to it, and the committee will ask you for it?
I would always recommend the city secretary hold on to something if it's handed to him. I don't want to lose evidence. Unless it's some sort of food product that's going to start smelling his office up, or something that's very odorous and would get me kicked out of City Hall, I would probably always recommend that Thomas's office hold on to it so that we don't lose anything.
I mean, is there on that signed sworn complaint, is there an area that you check or you say there's evidence, or what is that complaint? I mean, could there be a link to that complaint form, or?
We don't have a standardized form. We will take it basically, if it's in writing and you've signed it and we can get it notarized on the bottom, we'll take it. The ordinance does require you to give enough facts for me to make a determination as to who the person is and whether or not it's an item within the purview of the Code of Ethics. The more information they provide, the better it is. But that leads us up to the next part where you have to conduct an investigation if there's not enough information. But we are not going to turn somebody away because they didn't use some standardized form we made. We will take it on a napkin if that makes them happy.
And it's large enough to be notarized.
Flip the napkin over. Okay.
Let's see. So, and I'm just going to skim through, but the Meredith's office or the city attorney reviews and dismisses if it doesn't meet the criteria, or we receive it forwarded to us. On the good faith reliance, do we need a definition around that, or is that standard?
You told me. You got a definition of it?
I'm trying to, have a procedure that if I'm a complainant and I'm submitting something and then I'm able to review what the procedures will look like, what does that mean? If that makes sense.
If you have something really specific, then you may rule out other things. If that's a general sentence, like it's similar to what Andrew said earlier about if you're going to be very specific about, it's this kind of social media, that kind of social media, then as time changes, you keep having to change what you have defined. So I think good faith, I think it might be individual. I don't know if that makes sense. I think it might be specific to the case that comes up. Like if you define it, you may be leaving out things that could be included.
Or a little bit of Amy. Oh, go ahead.
Hi, everyone. Yeah, this is Raquel. Sorry that I had to join a little later, but when I read that, the procedures, I was not sure what that meant exactly, and I was wondering if that was legalese and if there was a standard definition, regardless of situation. I think that would be useful.
I can tell you that if you wanted to translate it from legalese, it would be basically an honest or sincerely held belief. So you honestly relied or you sincerely. It's pretty abstract, but I'm happy to write one if you want one and look at it for next time.
I still think it would be specific to the case.
Since we have to,
I am reading a quick definition. So it says good faith reliance means there's been relevant issues raised, question the information provided, assumptions used, and assess whether the analysis provided. Basically, the person that's looking at the data or the evidence basically says, it's reasonable. What's being said is reasonable. I mean, I'm sure there's different definitions, but I mean, maybe if we're going to use that term, it may be helpful to have it under definitions.
Since, there's some conflicting opinions around it, Meredith, if you wouldn't mind drafting some language and then we could see what it says and see if it has value or relevance. And if it doesn't, we won't include it. And if it does, then we could incorporate. Is everyone okay with that?
That sounds good.
Any other comments around section B and C or subsection?
Yes, please. Oh, I'm sorry, you said C. You didn't get to D yet. Never mind.
No, go ahead, please. Well,
D is where I need your most help.
Oh, the review by IERB?
I'm sorry, D like David?
Oh, D like David. Under the investigation portion? We'll wrap up A and get there quickly. Any other comments around the timeline on the subsection 4? So A sub 4, or any other comments under section A that warrant discussion? Okay. And if I move too quickly and you want to go back to something, just shout. Under section B, which is the review by the IERB, any particular comments, concerns, questions? And let's see, section C, response from the respondents. Within 10 calendar days from receiving the decision to proceed, respondent may file a response to the complaint with the IRB.
On the suggestions where it says subpoenas to the complainant or accused for documents, and then underneath request material witnesses for public hearing, do we have the authority to subpoena witnesses and documents and evidence, or can we only deal with what we're given?
We will do everything we possibly can to give you that power.
Okay.
It is most likely going to be.
Do we currently have that?
I cannot definitively answer that. It's not very clear in state law. We are going to operate as if you do.
Okay.
So is it, since it's not unclear, we have the right to request. It's just whether or not we can actually compel them to provide it. Is that what we're, okay.
Yes, ma'am.
So Andrew, I had the same thoughts around that when I got to that, whether or not we were actually able to. And in addition to that, when we're requesting material witnesses and asking someone to participate, it's my understanding that can be declined. Is that right? So
if they're not a city official, a city employee, yes, they can decline to participate.
now, if they are a city official or a city employee, they do not have that ability to decline.
If they're a city employee, absolutely don't have that ability. If they're a city official, then you have to look and see if that in itself, failing to comply the process, would be some sort of violation of the code.
Okay.
So as far as these three items being suggestions, I'd like to see them put in there officially. Because I think Meredith was just suggesting these, but she would like to add, and I'd like to say, yes, I'd like to have them.
I agree.
Can you add to the list? I suspect there's a lot more information you're going to want to be able to hold a hearing.
So I want to give everyone the chance, since we're in section D.
I can't, I mean, we can ask people and we can ask for, information and stuff. I don't know what else I would want to ask for. Now, my question in the later sections is, what do we do with that stuff once we have it?
That's what I would like to go into in this section. I believe that this would be a meeting prior to your hearing where you're doing a fact finding, and I'm looking for guidance so I can draft some procedures for you as to how you want to conduct that meeting, how you want to receive the information, how you want to review it at that point, so that we can then schedule a hearing once you have that information. Or if once you have that information, you want to say, we no longer need a hearing, we're done. Actually, that's not correct. You have to act in a hearing. So I retract my last sentence.
So would a statement like something like reviews the documentation provided and engages in independent fact finding to the extent necessary? I'm just reading from something, I did a little research on this section, and so would you want a statement like something about reviews and analyzes the documentation to engage in fact finding to the extent necessary to clarify, expand, or corroborate the information provided? Like, would that be helpful in this section?
Could you email me that? That's beautiful language.
I'll put it in the chat room. I'll just copy and paste it. It's okay.
So that sounds like we'll have another meeting to review the information that we gather and decide what's pertinent or not. One of my questions is, do we then provide that information to the complainant and the respondent before the hearing? And maybe that help negotiate the settlement process one way or the other? Or do we wait till the hearing to bring that out in the public? And if we do wait till the hearing, in what order?
Your meetings are open to the public, so I suspect that the complainant and the respondent will probably be sitting there while you're going through your investigation.
Good point.
I cannot provide you the document outside of the public process, so you can't get the information at home and then come back with your decisions. All facts must be provided while you're sitting together as a quorum. You can receive the facts in the meeting, say, this is good, I think you've given me enough documents. You can ask me to get you more documents. You can ask for more witnesses. But once you get that information, your discussion on it really does need to occur during the hearing itself, any deliberation related to that information.
It makes good sense. I like that.
To that end, I mean, there can be numerous meetings prior to a hearing, right? So, I mean, you call your witnesses as to whomever you wish to speak with, and then, you know, it's like a scheduling component, right? Where, go ahead.
You're actually not speaking with the witnesses at this time. You're telling us based on your witness questioning will occur during the hearing. The purpose of the investigation is for you to get facts. You read the facts and you say, you know what? And I wish I could remember more of the facts of the case you all had last time, because you were like, you know, it would have been helpful had we known this information. It'd be helpful if we knew that information. And so when you get a copy of the complaint, we come forward to the first meeting, it would be, you know, we noticed that it's a complaint based on this. We want this policy. We need minutes of this meeting. We want a copy of this, so that you can make sure that when you actually have the hearing, you get whatever you want. It's kind of an abbreviated discovery process, but that way we ensure that you have whatever you need once the hearing occurs.
So what happens in the hearing if, and I know we don't have a case at hand to discuss, but what happens if a witness is being interviewed during the actual hearing and brings forth a whole different component of the complaint itself? So something new comes to light that warrants more document research, more investigation, and additional witnesses.
At that point in time, you can ask to recess and direct us to provide more information, and you'll come back and continue the hearing once you receive the additional information.
Okay, so the hearing is not necessarily like a one-time date and time. It's a process that may be one day, but also could continue on.
Yes, ma'am. That is why it's so important for the alternates to be participating, or at least sitting in the audience and receiving all of that information. Mm-hmm. Because if it does carry on, they need to know everything that you know, so that they're able to vote, so that we do have a full panel.
When documents are provided, are all documents provided to both the complainant and the respondent?
Once you get to the hearing, yes, ma'am. Everybody will get everything.
At that time, or yes, never mind. That answers that question. Yes.
So, Maris, sorry, we had talked about sort of having a pre-meeting to the hearing. So if I'm hearing you correctly, is that anytime we meet, it would be in the hearing format?
No. What I'm trying to do with the investigation is your pre-meeting, mm-hmm. and trying to determine what you want that pre-meeting to be, but you cannot actually deliberate on what the facts are unless you have what is the official hearing, which would be like a trial. And so what I'm trying to capture here is exactly what you mentioned in your last meeting, the pre-meeting.
Okay. And so really this meeting is about looking at the complaint and asking questions with regards to additional information that may be needed in order to go into the hearing.
Perfect. Yes, ma'am. That's exactly what I'm trying to accomplish.
Okay. And I really like the fact-finding comment that Ann came up with, because I think it just needs to be all-encompassing depending upon what the complaint is. I know in the last one, like you said, there was a laundry list of things that people came up with.
Raquel, I believe you had specific comments for this particular section, or questions or additions. Is that right?
Can you hear me?
Yes.
Okay. I don't at this time. I don't have anything. Thank you.
Oh, I'm sorry. I thought there was a particular section that you, is it section D underneath the hearing process itself?
No, I was just referring to that definition.
Okay.
I'm in my car and not like able to look at the documents, but I don't have anything else at this time. I think the question I had has been resolved around the definition.
Not a problem. Just wanted to make sure you had that opportunity.
Thank you.
So back to, I believe it was Fred that mentioned this. I mean, there's documents to review, so we'll come. When we're in the investigation component, that's essentially what you were saying, like, is our fact-finding, brainstorming, what do we want to see? Who do we want to speak with?
Right, I think we've covered that. That's good.
I agree. But beyond that, I'm trying to think about what else in that particular meeting we would need to either discuss or request. Is there anything else?
I can't think of it.
Okay. The settlement process, section E. Any considerations, suggestions?
I have a question on that. If they came to us and they wanted to have a settlement, we're required that settlement be public? Or can they say, look, I'll plead guilty if we don't make it public? Or I'll pay the fine if we don't tell everyone how much I paid. I think everything we do has to be clearly visible to the public. It's the whole purpose of our panel. If that were to come up.
Being a government entity, it's almost impossible to make things confidential.
Okay.
But anything this board does or sees would have to be transparent. We would be open meetings and it'd be open records. I would completely caution you against doing anything in the dark.
Oh, no, I wouldn't want to, but if somebody said, look, let's just make this go away, and, my feeling would be too bad if you're going to say you're guilty, you're saying guilty in public.
Well, I will tell you that once we do receive a sworn complaint that's valid, and we do post your first meeting, that complaint is now public information. It will be out there because the nature of your meeting will state what the complaint is.
Right. And then everything from that point on is public too. That even if they request that the final resolution not be made public in order to speed things up or end it or stuff, that they wouldn't be allowed to.
That's correct. It has to be public.
Okay.
So I guess to clarify, that decision to settle, that would have to be stated in that hearing, and like the proper documentation, all of that would be, I guess, read. How would that play out?
Yes, ma'am. If the board conducts the hearing or prior to the hearing itself, you still have your investigative process going on. If the respondent comes to you and says, hey, board, I would like to admit I screwed up. I'm so very sorry. I promise never to do it again. can we just settle this without having to do the full-blown hearing, and call it a day? Then the board would take a vote, yes or no, whether or not you're willing to accept the apology and go forward without that. And then the outside counsel I will have hired for this board, because it would be a conflict of interest for me to sit up there and provide you advice during the hearing. So you will have outside counsel for that. They will help you draft the settlement agreement, at which point you will review it and agree that this is the terms you want, sign off on it, and then the case is closed.
So is that
So that kind of disclosure then doesn't actually require a hearing?
It would not be a trial type hearing, but it's still going to be a public process. It'll still be an open meeting to the public.
Yes, got it. Okay.
that's the clarification I was actually just going to perhaps suggest in this section, is that the settlement process, it's essentially a meeting as well, right? So, you have your investigation process meeting, and then at any time, either the complainant or the board could request a settlement meeting or process, because it can be initiated by the board as well, right? Not just the complainant.
That's correct.
So would it be helpful to include that either party can request it, but it's an actual meeting, where like an open public meeting? I guess that part is redundant, but that it's an actual versus, because to me, sometimes this reads more like a document that somebody will submit a document to the board.
I can certainly make that change. The ordinance requires all action to be during the public hearing, so I would certainly make that change to the policy.
And Meredith, for the outside counsel, how soon how do we choose who they are, and how soon can that be done to stay within the time frames of when the hearing should be, or the whole process?
Actually, that's already pretty much done. I have a independent outside attorney who is a prosecutor, a judge, and represents other municipalities, and he's got a pretty impressive resume, but he has agreed that he could be on call at any point in time should we need him to do this. And I have a law firm as a backup if he is not available. But these are people that only practice municipal law, and so they should be very familiar with what a public official's responsibility is, no matter what their board is. They're competent in reading an ordinance. And so that would not be a problem for me to get somebody in here within the time frame.
Oh, and they're sufficiently distanced from connections with any of the city council members that we wouldn't have to go. Could be a conflict there.
The individual who is a solo law firm, as much as I would like to hire him to do contract work for us, because I do respect the work he's done for other cities, I don't hire him. He's been a substitute prosecutor for us twice because I was stuck. But otherwise, he has no contract with the city, so he would have no reason to have anything approved through city council or through any of the zoning items. He doesn't live within the city, so he should have no conflicts whatsoever. If we had to use the law firm, it's a decent-sized municipal law firm. It would be somebody who does not participate in the litigation side. So they will not have represented us or been in an executive session with any council members.
Cool. Thank you.
But thank you for pointing those out. I want to make sure that I'm above board. So I appreciate your help.
That's what you don't pay me for.
I am noticing that it's after 4 p.m. Is this something that we should table and continue discussion at our next meeting?
I think let's look at the changes we've talked about, then we can review and finish going through it.
Is that good with you, Meredith?
That works perfectly. I will make revisions so far. And once you have a document that you're happy with, we'll come back with another article of interest for you to try it out on. But
Sounds
I can
like
easily make revisions.
Can I make just one quick comment that I've been saving? So we're going to have these witnesses that we want to call. There's nowhere in the general hearing procedures for us to present those. So I just think that seems to be a line item added over into the hearing, that then the independent board presents their witnesses and documents or whatever during the hearing. I'm done.
I can certainly add that.
If there are no other items for discussion for today,
Meredith or Krista, I would like to add something that we can to discuss on the next meeting. Meredith, you and I had discussed an event in the last election that didn't seem to pass the smell test. Do you recall that?
Yes, I do. Did you want me to say what it is, or do you want to say what it is?
I can say it, and I'd like to discuss it at the next meeting when we have time. So in the last election, one of the allegations were made that one of the candidates' spouses had a fundraiser to pay off the campaign debt of a former city council member. And in exchange, that outgoing council member endorsed the candidate. And when that was pointed out to me, I didn't think it sounded right, but I don't know if there's anything we can do about that. But I wanted the other members to know about it and discuss it. Is that something we should add or see if our current document covers?
I will add that to the next agenda for discussion.
Okay.
and to that end, did the individual that discussed this with you wish to sign and swear and file it as a complaint?
They are more than welcome to do that, and I encourage them to further investigate what they had heard, and please come forward with it. But regardless of it, whether it happened or not in this particular case, I definitely think it's something that we have to look at, because if it didn't happen and it does happen, we'll definitely be dealing with it.
That will be listed as a hypothetical question.
Okay.
Which we do not have an official complaint.
Perfect. Are there any other items for discussion? May I have a motion to adjourn the meeting?
I make a motion to adjourn the meeting.
A second.
All right.
Ooh, that was fast.
All in favor?
Aye.
Aye.
All right. Meeting adjourned.